Right. Okay. So I think the first question for the gentleman, what are my fears for Ghana's democracy as a result of the entry of no-prosecution reform cases? First of all, I look at everything from the perspective of public accountability. It's very important that there's accountability for all officers who hold offices which are deemed to be public trust. So if you occupy a public office, you're supposed to be a trustee of public power and authority. And therefore, one should have no difficulty at all accounting for one's stewardship. And so when persons are prosecuted for specific financial crimes and all, it assumes a greater importance because indeed it borders on the use of the public purse, which they are supposed to be trustees of and what have you. Therefore, as far as I'm concerned, there ought to be a determination of the merits of the offense that the person has been charged with. And it becomes therefore worrying when, after courts of law have established that it's a case for a public officer to answer in respect of a specific financial offense that he has been charged with, an attorney general exercises discretion, evaluates evidence in his chambers, calls on counsel for the defense, and say that indeed that accused person ought not to open his defense and that the case is closed. It becomes more worrying when indeed the effect of that is to confer what we call in law an acquittal, which is akin to a determination of no wrongdoing by the accused person. But that's a judgment that ordinarily ought to be passed by a court of law. So my view is that once an accused person has been adjudged, that's the case for the accused person to answer. There's no basis at all for an attorney general to sit in his office or his chambers to scrutinize the evidence and speak to counsel for the defense and say that the accused person ought not to answer. And even impliedly confer an acquittal on that accused person. It's unconscionable. And I would think that there's actually sufficient basis for a questioning of the provision in the Criminal Offences and Other Offences Procedure Act 30, which effectively confers on the Attorney General the power to pass a verdict on a crime that has been that a person has been charged with. But effectively, if that's the case, then it means all an attorney general should do, especially, I had been a holder of the office, I can cite myself. So various allegations have been made against certain ministers, maybe without any basis at all. I just can collude with Minister A and say, Minister A, let's quickly file a case against you in the course of Ghana. Once the case has been filed, we call a few witnesses, close our defense, and then close our case, call upon the accused person to open his defense. Once it starts, then I enter a withdrawal, and the person would have been acquitted. And there cannot be a reopening of that case. Because once the person has been acquitted, it ends the matter. I think it provides basis for sufficient abuse, especially in all these cases. You saw there's a case that had been made, the court held that Stephen Okunin was a case for him to answer, Stephen Okunin and two others. They went all the way up to Supreme Court. They did not succeed. Same happened in Thompson. Some count, the court said, indeed, there was a case for him to answer, as well as Ofusuampo. Ofusuampo, for the same day that Atufosi was acquitted by the court for appeal, the same panel actually held that Ofusuampo had the case to answer. And subsequently, the attorney general comes less than a year and says the person has no case to answer. So that's my view. It provides basis for abuse, and indeed, you must look at it from the point of public accountability. An attorney general, by the exercise of such powers, and effectively shield members of the public from public accountability. Then, commendation by various persons for the press conference by Dr. Union. Yes, the Agogo Afoku matter. So you must make a distinction between legal principles of law and what may be allowed. Or what may be proper. So, in the eyes of the law, the exercise of the power of no prosecution is not subject to questioning at all. So, when the attorney general contends in court, which I did when I was deputy attorney general in the Oku matter, that the then Attorney General, Madame Gloria, was not required to account for the entry of the nolle prosequi. That position is correct, but nolle prosequi is one of the means by which the Attorney General controls the conduct of prosecution. And indeed, I find it a little bit innocuous because it doesn't result in an acquittal of an accused person. It doesn't result in the Attorney General exercising the power to pass judgment on the conduct of any accused person. A nolle prosequi only results in a termination of proceedings. A future Attorney General who finds merit in the case can revive it and go to court. Indeed, the same Attorney General may even just want to reorganize and come back, which we did actually in the Afuku case. The entry of nolle prosequi was because they had arrested the second culprit in the matter, whose role was deemed to be crucial. And the then Attorney General deemed it fit to commence proceedings again. And we did it. We didn't just enter nolle prosequi and whitewash the person's crime. So I think that if an Attorney General decides to open up on the reasons for entry of nolle prosequi and withdrawal, well, it's something that is permissible, but of course it's not legally the Attorney General is not legally compelled to do that. And indeed, I have on many occasions actually issued press statements, as we all know. The record shows I issued press statements even after the court ordered a mistrial in the Afuku matter and other matters explaining. So it is something that I think that ought to be tolerated and ought to be encouraged and all. But the fundamental question is, what were the motives for the press conference? And as I've disclosed, the motive for the press conference was just to whitewash, was just to explain. He himself knew that there had been a public backlash, there had been a reduction of the goodwill that they thought the NEC had in the beginning by the entry of these withdrawals and all that. The public was really appalled by the manner in which these withdrawals were done, especially when it burdened the use of the public funds. And those were really the true motives for the holding of the press conference by Dr. Ayine and nothing more. And regarding Richard Japa, yes. So I think that, as I said, the full facts were actually unraveled in the course of court proceedings. The tape was played many times. Even when Japa was in the witness box, the tape was played again. I proceeded to cross-examine him. The DPP had earlier on cross-examined the allegations affecting me personally because I deemed that no, you cannot be saying things. I said this, I didn't say that, and that kind of thing. It becomes a little bit awkward. So the DPP exercised I told the DPP to conduct that part. And the main cases, the main case affecting Japa, I did that. When I was cross-examining, he never even brought it up because he knew the allegations that were made in the media were totally false. The true facts are simple. I've never met Richard Japa anywhere in my life apart from the courtroom and on a few occasions in the house of a Justice of the Supreme Court, Justice Yoni Kulendi. And that's because I have never arranged any meeting with him. I mean, Justice Kulendi is a very respected figure in Ghana, a former member of the same firm that I trained the Kufari Pepenko, and we had good relations before he became a judge. In fact, it's even important to note that the house that I live in, which I bought in 2014, I bought it from Justice Kulendi's client. So we have had that when he was a lawyer, practicing lawyer, and I don't think he even wanted to go to the Supreme Court at that time. So we had that very good relationship and all. So a few occasions, maybe a Christmas party, Easter time, and that kind of thing, I'll go to Kulendi's house. Occasionally, he will call me. He had not seen a long while. Oh, no, I'll come over, and I come over. Then I met him on those few occasions. The interactions we had did not bother anything at all. And indeed, on one of the visits, the very last visit, I knew that he was not well. It's a matter of record. And the record of proceedings in the court showed that even the day in question, his own counsel had called the DDP to arrange an adjournment because he knew his client was not well. And the case came on, the judge asked the lawyer for the accused actually requested that they go into chambers and discuss matters bordering on adjournment. Again, because of the awareness of Richard Japa. And they went, and because of the awareness of Richard Japa, an adjournment was granted. Incidentally, that week happened to be the week just preceding an international arbitration that I had in the United Kingdom. As a matter of record, look at all the dates and all. The hearing of the GC net matter, which subsequently the government of Ghana won, was on the Monday after the secret recording by Richard Japa, which was on either the Tuesday or the Thursday. So, and the transfer arbitration proceedings are so voluminous. And whilst in office, I cultivated the habit of conducting most international arbitration cases ourselves. Myself and my deputy, Dana, Snowball Dapa, and all who will go with other state attorneys and all. So the case against Richard Japa used to come on Tuesday and Thursday. By the Thursday, if you are attending, you are burning a lot of work. Cabinet, National Security Council, court, everything. You must try and do all together. So on the very Thursday, I think it was the Thursday or so, Tuesday or Thursday, I realized I had to really prepare for the international arbitration. Otherwise, the hearing that was supposed to come up the next Monday, I would be very much troubled. So by 12 p.m., by 11 a.m., and the matter was speaking at 12 a.m., I realized I was still not really ready or in a position to do my study. And that was a single phone call that I made to him, which was the serious matter of the proceedings. As so I went to call him just to, because indeed I knew he was not well. And that day, as I said, he actually went to court and got an adjournment because it was not well. I just called him in that conversation, not knowing he himself had that illicit agenda and was secretly recording and was saying the things that he got on the tape, which the judge said that those things, if you look at them, came from him and not from me. That's why I said, so you yourself, you're not one the day I met you. So is it possible? He said, he's afraid because the judge had earlier on, it was a matter of fact as well, issued a bench warrant for his arrest. And so he was afraid to obtain or to apply for excuse from court proceedings on basis of being unwell. I said, you can get a medical report. That was exactly what happened. Then he said, he's a little too late, he's afraid of the judge. And they went. But when they went, he actually obtained an adjournment because it was not well. So the fact of my asking him to obtain medical certificate because it was not well was nothing but factual. Was not an attempt to get him to procure any evidence or anything at all. That is it.